tablet. Big smile, everyone.
Okay. I think it's started. Yep, we're live.
Hello, everyone, and thanks for joining us. So we're live, and I appreciate you clicking on the links and joining us. We hope that nothing goes wrong. If you could only see our cramped little studio here, we've done everything we possibly can to try to make this as entertaining and as visually stimulating as possible. So we're going to do our best to keep your attention for as long as we can, and we're going to jump right into it. My name is Sam Guillen. I'm the Director of Training here at Berkshire Hathaway Home Services California Properties, and I'm joined by two amazing people. One is Martha Mosier, our General Counsel, and then Dean Stalter, our Broker of Record. And we're going to be doing this once a month for you. We're going to come live once a month on the last Tuesday of every month to share with you legal tips and hot points and case studies and revised forms and best practices and all of that jazz, right? So hopefully you're as excited as we are about this, and so let's get right into this, okay? All right, so first thing we're going to talk about are a couple of case studies as we close out the 2018 year. And one of those case studies is something that we're calling the case of the angry neighbor, Martha. So,
Yes.
And you should see a nice gentleman on your screen here.
Like this morning.
Okay, very
It's
good.
like a mugshot, yeah.
So, Martha, tell us a little bit about this case.
Yeah, well, this was a really interesting case that Sam asked me for a couple of the most recent cases, and as a matter of fact, we just settled this case last week. So it's fresh in my mind, and I wanted to present it to you today because it explores an issue that we see quite often. Do you disclose a disgruntled, an angry, a mean, a belligerent, nuisance neighbor? 100% yes, you do. And in this situation, we had a very volatile, interesting individual living next door to the house in question. We represented buyer only, and our agent received an email just shortly before the close of escrow that, oh, by the way, the seller of the property and the adjoining neighbor had a ongoing dispute for a while. It's been resolved, everything's okay, but there was some hostility between the two that gave rise to some legal action, but everything is fine. So our agent took that and decided, well, you know what, everything's fine, sounds like, it's a personal matter, it's not going to affect my buyer, and did not transmit that email over to the buyer. Remember, we represent buyer only. So what happens? Escrow closes, buyer moves onto the property, and guess what? You guessed it. All right. Within 1 week of the close of escrow, this angry individual, and that's not really his picture, but he looked a lot like that. He provoked the buyer, our client, and they engaged in a dispute, which resulted in a fist fight, which resulted in the police being called, and this went on and on and on for the better part of 6 months before the buyer reached out and said, hey, did anyone know about this crazy guy next door? I have young children. He's doing horrible things. He uses profanity in his backyard. He's a nuisance. And sure enough, the agent for the seller said, oh, sure, yeah, I sent that email over to your agent regarding this individual. And so suffice it to say, we were sued as well as our agent. And unfortunately, when you have possession of a disclosure regarding something like this and you don't pass it on to your client, not only are you sued for negligence, but you're sued for concealment and fraud and those other things. So we were able to extricate our agent out of this matter and the company out of the matter, but not after a little bit of a legal battle.
Wow, so the moral of the story here is if I get something that we think is a disclosable thing, but we think that it was settled and no longer an issue, we should still disclose, regardless of how we feel that it's either been resolved or not.
Absolutely. No matter what, let buyers satisfy themselves as to that.
I always feel like it's better to say too much than too little.
Absolutely. Always, always, always. All right. So the next case study, another one fresh in everybody's mind, is the case. And this is a big one because we're getting a lot of these types of cases lately, right?
We are.
This is the case of the garage that is not livable. So what are we talking about here?
Well, many times builders, buyers, sellers, all the individuals involved in a transaction don't really realize that a garage is not livable square feet. I mean, I for one had a son that tried to move out into my garage once and converted into his own pad, but it is not considered livable square feet no matter how you slice it or dice it or how you design it. So basically what happened here was we were listing the property and we looked on our agent was a listing agent, looked on the tax rolls and the county tax assessor and realized that the property was 3,000 square feet, despite the fact our seller said, no, I spent hundreds of thousands of dollars on this beautiful remodel, it's 4,000 square feet. I want to sell it at 4,000 square feet, price per square foot is X amount, do the math. So we bumped the list price up and we entered it in the MLS as 4,000 square feet rather than 3. Now, on this case, our agent did a little bit of due diligence here and said, well, wait a minute, to the seller, wait a minute, the county tax assessor says 3,000, you're telling me 4, alarm should go off, discrepancy, and he said, well, call my builder. So the agent did. The agent called the builder and said, hey, Bob Builder, what's the square footage of this house? He said, I did the remodel, 4,000 square feet. Boom, put it in the MLS. Of course, property closes, and guess what happens? The buyer discovers
it's not 4,000
it's not 4,000 square feet. And so, of course, we go back to the builder, and the builder said, I never said anything. You know, I don't know what you're talking about. So there was never a confirmation in writing. So we didn't cite our source. We basically just made a representation to the world and to the buyer and to the buyer's agent that this property was in fact 4,000 square feet when really it wasn't. It was about 3,500 square feet. It was 4,000 if you include the 500 square foot garage.
And so many people just don't understand that. And there's a difference when you're hiring a contractor and you have plans laid out, and the contractor is really doing their estimates and their preparation on the total construction. And for them, it's 4,000 square feet.
It is
because that's what they're building, right? But for the purposes of real estate, you're really only looking at 3,500 square feet of livable space.
That's right.
And so it's our job, it's a practitioner's job to be able to educate the sellers and help them understand that, you know, whatever we're putting in the MLS and what the claims that we're making, they have to be that livable square footage that everybody would consider livable.
Absolutely. And we do have the standalone form now that we've created this year as of 2018. We created with the work of the 3 lawyers. I think Sam, you were in on it. Dean, I think you were in on it. So there were a lot of people working on this form. We managed to get all the disclosures on one page with the signature block, and it's the lot size, square footage, disclosure, and advisory that we have. It's the BHHS in our library, and get the seller to sign that. Because in that case, that would have been our nice, you know, get out of jail free card, so to speak, in that case if we would have had that filled out, showing the discrepancies.
And so make sure you fill out that form, make sure that the seller puts pen to paper on that, much like the transfer disclosure statement. We want them filling that out themselves and disclosing as many sources that you have that have a discrepancy on there, okay? So, and take the time to educate the seller. You know, our obligation is to provide outstanding service to our clients, and this includes educating them about these different sources and what we can't use, okay? So next we're going to go on now talk about some new forms. So in 2018, actually specifically in December, the California Association of Realtors and the standard forms that they create, well, every year they have updates. They have updates, and they often will add new forms in. They do it twice a year, once in December and then once in June. So we just had a new forms release, or an update at least, that came up. So we're going to talk to you about some of those forms, some of the more important ones that we think that you use on a regular basis. And so one of those forms is the one that we all use and that we have to sign before we sign any contract, and that is the agency disclosure form, which is the disclosure regarding agency relationships, otherwise known as CAR form AD. So Dean, what are some of the changes on this form?
Yeah, thanks, Sam. You know, we talked a little bit about this last week, but it's just so important we wanted to touch on it one more time. But the biggest thing is, you know, for years we've been trained that there's 3 different agency disclosures. So that there's the buyer's agent to the buyer, there's the seller's agent to the seller, and then there's the co-op buyer's agent to the seller again. So that third one threw a lot of people off. I'm sure it drove a lot of transaction coordinators crazy trying to chase that down. So in this cleanup legislation, they eliminated that third agency, and so now it's just the 2. One of the things that they also did to hopefully simplify this form a little bit for you is they changed some of the language in it. So now the selling agent is called the buyer's agent. The listing agent is the seller's agent. The purchaser is now called the buyer. And the associate licensees are now the salesperson or the broker associates. So the other change that you'll notice in here is that when you represent the buyer and the seller, so we have dual agency, it might even be another agent from another Berkshire office under our brokerage, but it still creates a dual agency situation. So in that case, they broaden the protections. Previously, in a dual agency, we were not allowed to disclose if the seller would sell their property for anything less than what their list price was. And we couldn't disclose if the buyer was willing to pay more than what their offer price was. So they've expanded that a little bit, and they've included some different terms in there. So in addition to those 2, they've included the financial position of either party, their motivations, their bargaining position, or personal information that might impact the price. So basically this is anything that might put the other party at a financial or a competitive disadvantage. So things like divorce, financial situations, bankruptcy, pending short sales, whatever it is that could affect those parties are now confidential and can't be shared in a dual situation.
All right, so the good news is that they've cleaned up the language and it's really straightforward now, right? So we don't ever have to worry about, so the selling agent, who is the selling agent and who is the agent it was just a mess. And so now it's really straightforward. The listing agent, buyer's agent, right. Seller, buyer, really simple. So kudos to CAR for getting that one right. And but there's also a new, not a new form, but I suppose they've made some substantial changes to this, and that is on the confirmation of real estate agency relationships. This is Form AC. Now, a lot of you may not use this form, but there is some very specific reasons why you would. Why would they use this form? Right.
Well, the standalone confirmation of real estate agency would be used if you were not using a CAR purchase agreement, because your CAR purchase agreement, as you can tell on the slide, incorporates the confirmation of agency always on page 1 of the RPA and all purchase agreements. So if you're using purchase agreements with new builders, just maybe larger type of estates often use purchase agreements that are drafted by attorneys and they don't use CAR forms. Some commercial agreements do not use CAR forms. So it's best to use the standalone form if you are not using an RPA. That's the only time you would technically use this, or if you needed to clean something up. Yeah. In other words, if we had an RPA that maybe you didn't fill it out correctly, and I suspect there may be some issues with that initially because this form has changed and the actual way you fill out confirmation has changed. So it's kind of designed as a cleanup as well as using it in the event you're not using a CAR form. What's probably most important to note, and I know we have the new changes to the RPA coming up, but I'll even mention it twice. It warrants mentioning twice. And that is, you will see in the confirmation of agency for both the buyer and the seller that CAR has added a line for the broker as well as the agent. This is very important to note that if the buyer broker and the seller's broker are the same brokerage, Berkshire Hathaway Home Services California Properties, you will always check that we're representing both sides. We are a dual agent. If Sam is representing the buyer in La Jolla and Dean is in Rancho Bernardo representing the seller, and they're both at Berkshire Hathaway Home Services California Properties offices, they are both dual agents. Under the eyeballs of the law, you are dual agents, even though you don't consider yourself dual. It's not a dual where Dean's representing both buyer and seller. They're both at the same brokerage. You check the box that says that they're representing both buyer and seller.
Now that can be a little confusing when you look at this form and,
Sure.
and on the new RPA when we get to it, because there is, in both the selling brokerage firm and buyer brokerage firm confirmation, there are two lines,
Yes,
right?
there
So
are.
there is now a line for seller's brokerage, and this is where you would put Berkshire Hathaway Home Services California Properties. But yet there's another line now that says seller agent, or down in the buyer side where it says buyer agent, right?
Correct.
And then you have the ability to check boxes that say representing the buyer only or the seller only. And so you may think, correct, Martha, that because Dean's representing the seller and I'm representing the buyer,
Right.
while my brokerage may be representing both sides, I specifically am only representing the buyer. However, that's not correct, right?
That's not
we
correct.
still have to be able to check both buyer and seller representing both. Is that correct?
That is correct. That is correct. There's
Okay.
And if you're a single agent, dual agency, I think they are looking for the agent's name to go in here twice, the selling agent and the buyer's agent, so it's obvious that it's single agent, dual agency.
Got it. So if everybody gets that right, so if you are a legitimate dual agency, your name has to be there twice, right?
Yep.
That's what they're looking for. So not just on the top or the bottom. Okay.
You don't
Right.
ever want to confuse a consumer or give a lawyer a right to say fodder to say it wasn't disclosed. So if you've got it in there twice, it's unquestionable that you're a dual agent.
Yep. All right. So the next form is, it just gives me creepies just talking about it. It is the bed bug disclosure, right? I can feel things crawling on me already. So this form is pretty straightforward. It just actually puts in, if you can see there towards the bottom of that page, in a square box, it essentially holds the landlord, the agents involved, harmless to anybody who doesn't comply to this bed bug disclosure. Is that correct, Dean?
Yeah, so it's the tenant's failure to comply with the bed bug disclosure.
Yes.
That's hard to say. The other thing it does is it kind of puts the onus on the tenant to report to the landlord when they suspect they have a bed bug infestation.
So that's important to know. So if they have it, they have to notify the landlords. Now, we don't manage property, however.
That's correct.
Right?
That's correct.
So this is an important, I think it's an important point that we have to make. So as a company, we find and help secure tenants.
Correct.
Right? And we go through that process and facilitate that contract between a homeowner or landlord and their new tenant. Then we're hands off.
That's right.
And so it's really incumbent upon the tenant to notify the landlord, and that's really what this disclosure is saying, right? So in some of those events where that tenant may feel compelled to call you, the agents, right? What do we do?
Right. I would refer them back to the landlord or the property manager.
And if we're representing the landlord, Sam,
Representing.
then we do have to provide this bed bug disclosure as part of the documents that the landlord gives to the tenant. So he puts it out there, but any management portion is going to go back to the landlord.
So it's a fine line, though, isn't it?
It is.
It really is a fine line, because if we start getting involved in this process, we could be seen as property managers.
We
yes?
could, absolutely.
So it's important to make sure that you make it clear once you facilitate this new tenant for the landlord. Hey, if you find anything, including bed bugs, call the landlord. And here's the number where you can do that, right?
Right.
Okay, very good. Next document that we have here is, and many of you probably don't use this document. Many of you just allow escrow to handle this for you. But it is the new homeowner association information request form. That's the CAR form, HOAIR form. And they've added a ton of language in here.
Yeah.
So I would encourage you, for time purposes, we're not going to go through this or have any further discussion, but I would encourage you to go through and read this in its entirety because it gives you some good information, but your escrow companies, especially Pickford Escrow or the escrow firm, will absolutely take care of all of this for you, okay? All right, next one is the receipt for reports. And there's only a couple of things that we want to point out in here. They did add now sections in there for a roof inspection, a sewer lateral report, and then the NHD report. Those are all three reports that are commonly used.
Correct.
And I'll speak to the sewer lateral report. I have to tell you, I don't see this enough.
Especially in older properties.
Especially in older homes, right?
Yep.
I really think that you should be having your buyers, let them know that it's as important as all the other inspections. I know it's probably not all that exciting because who wants to look down a camera that's going down sewage lines, right? I mean, but it is so important because, when they move in and suddenly they've got a yard full of sewage.
We have a potential case on that subject right now.
Oh. So, I think it's a terrific that they put this in here, and hopefully we'll have more buyers electing to do that inspection. Okay. So.
And Sam, this is a great form to use when there's been a previous BHHS transaction done on the property, and we're trying to furnish those disclosures from the previous deal. It just gives us another way to document the documents that were passed to the buyer from the previous transaction.
That makes a lot of sense.
This is a great form. I love it.
It is. It really is. Okay. And the next, some changes to the next one are the residential listing agreement. Now, the first page doesn't really have any changes to it, but the second page does. And on that second page, there is a on section 16 where the seller now, if you check that box, you're making it known that they told you that they have a contingency to purchase a replacement property.
Right.
So, Martha,
this is
a
great addition.
Why this is in here now?
Right. We lobbied hard for this addition simply because there were too many cases and incidents where sellers said, "Wait a minute, I told you I need to find a replacement property, and you got me into escrow." Right, and believe it or not, unfortunately, this occurs often with elderly individuals, and so we've got a couple elder abuse cases right now where the seller said, "Wait a minute, I'm in escrow. Wait a minute, I'm closing in 30 days. Wait, I have to pack and move," and it can be very disheartening. So this definitely helps the seller understand and the agent understand that there's an understanding that the seller must find replacement property before the close. So it's wonderful that they have added it in.
And this comes up quite a bit. We handle the listing, we put the transaction together, but in so many cases, we leave it to the seller to find out where they're going when they close their home. So this kind of puts us on notice that they have that contingency which protects them. That they have to find their next property, but it also is a good reminder for us that they may need help in identifying a property or even making arrangements to move to their next property if they're not making a purchase.
Yep.
Very, very important stuff. So moving on to our next document, changes to the residential purchase agreement. So this is one that everyone uses often, and hopefully you're using them frequently, and we'll use it even more in 2019. But right at the top on section 2B, this is where we alluded to earlier on the agency confirmation, where they have multiple lines in there, and so it's important that you fill those out appropriately. Do you want to reiterate, Martha, what we were talking about on that?
Sure. In case you missed it earlier, if the confirmation of agency, the seller's brokerage firm and the buyer's brokerage firm are identical, it is so imperative that you check the box, the far right box on both sections, that you are representing both the buyer and the seller. It sounds counterintuitive, but if the brokerages line up, that is in fact a dual agency. And then there is not the last page on here, but it warrants mentioning. there is a new rule, an NAR Code of Ethics Rule 1-7. And basically that states that if the buyer's agent asks the listing agent if they have presented the offer, they have a right to get confirmation that the offer was presented.
Good catch.
So you need to make sure, if you look at that, it even references it on the very last page of the RPA regarding rejection. Was the offer presented? Was it rejected? A good best practices rule would be make sure you fill that in. In the past, we haven't filled that in as a matter of practice. I think now it is incumbent upon you as the listing agent to absolutely identify what date and time you presented that offer to the seller. And I would actually go the extra step and have your seller sign the rejection. Because when Sam calls and said, hey, I don't think you presented my offer, my buyer's offer, you can say, I'm sorry, Sam, are you requesting that I show you proof? And you could just send over the rejection of the seller's initials.
This is a conversation that comes up so much.
Yes,
it does.
Particularly with multiple offers.
It does.
I hear about this when I'm traveling through the offices or in training. I get this question so much, right? How do I know that the listing agent actually presented my offer, right?
Yeah.
And so
Yeah.
this
the buyer
is
wants to know that.
the buyer wants to
Yes.
know. We have an obligation to be able to let them know rather than just saying, well, we don't know, we can't know. Well, now we have the ability to be able to do that, all right? All right, so moving on. And by the way, so we will begin hosting webinars that will really hone into some of these forms very specifically, so we can go through and reinforce what we're talking about here. You know, this is kind of quick and we're going through a lot of information. So look for webinars coming soon that you can register for that will talk specifically on the RPA, more advanced information, not necessarily, you know, like a basic overview, but more of an advanced overview. And we can even talk strategy, we can even talk best practices. So look for that coming soon. In fact, if you're interested, send an email and we'll let you know when we have one posted. Send an email to training@bhhscal.com. That's training@bhhscal.com. And we'll let you know about all of the kind of advanced webinars that we'll be having on these subjects, okay? All right. Next form that we're talking about here is the repairs requested, the RR form. Really not a whole lot of changes, just really down below on 1C on the repairs requested form. They do put, added some language in there that says any credit included in this paragraph is separate from any of the other credits that may be negotiated into the contract and doesn't automatically get reconciled or reduced or added to, right? So, Dean, why don't you speak to that and why this is in here?
Well, I was just going to say, you know, when you're writing the RPA, it's not unusual to have a credit built into the contract itself, but when the request for repairs comes along and the buyer has identified certain items that they're concerned about, and maybe the seller elects, rather than to do those repairs, they're going to give $1 credit in lieu of that. So if they give $1 credit, like it says here in 1C, then that's in addition to whatever the credit was negotiated in the RPA.
Very important to consider. So take a look at it.
We should also note that they've added the additional red language in here.
Oh, yes.
That the seller has no obligation to respond to buyer's request. Because so often, I think a lot of you have called us and said, oh my gosh, my buyer's livid that they're not responding. What's the time frame they have to respond?
And that,
they don't have to respond.
Yeah, and it's in the RPA, in section 14 of the RPA, section 14B, when it identifies that the buyer has the right to ask for repairs requested, but it says very clearly in there the seller has no obligation to even respond to it, right? So the buyer's only privilege in this is to ask, and then if they don't get a response, is to cancel the transaction.
Correct.
Right? Because I don't know about you, but I get a lot of questions. How can I compel them to at least say no? Well,
you can't.
You can't. So it's important to understand that, all right? All right, very good. Moving on.
You know, Sam, just
yes,
as
please.
a quick aside on that, if there's financing on the property, we have to make sure that we get these credits agreed to early enough so that the lender is informed. Hopefully it's before they draw a loan doc so they can make the calculations that they need to do the loan. And when we're giving credits at the last minute, like on the walkthrough, if they've already drawn loan docs, that's going to be problematic.
Yeah.
So just be aware timing is going to be an issue there.
Yep, absolutely. And there is that section, and the section number is escaping me, but there is a section in there that talks about the lender allowable credits.
Yes.
And how if there's any discrepancy between the lender allowable credits and the contractual credit, that doesn't automatically reduce the price or reconcile those numbers, right? So. And that's a much larger conversation, something that we teach in some of these advanced contract classes, so that you're really aware of how to deal with that if it should come up. Okay, so remember that. All right, next document is the single party compensation agreement,
Yes.
one that is often used in pocket listings.
Yes. Yes.
Tell us about that, Martha.
Well, it basically has expanded. What CAR did is they expanded the nomenclature in here, so they're now not just calling it the seller, they're calling it the principal. So this lovely form, which is a wonderful form, by the way, I refer a lot of agents to this form often when there is nothing in the MLS, or the MLS has expired or something like that. There is a single party compensation agreement, which is wonderful to use, but now CAR has expanded it so that you can also use it for lease scenarios, so that there's lease compensation.
That's a good thing. That's
Yep.
a really good thing.
It's a
because
great thing.
how often, if we can't get it sold, they say, well, how about if you just put together a lease for us,
Right.
right? And we
Right.
have a listing contract.
Right.
We don't necessarily have a lease contract, and we
That's right.
facilitate that. We don't want to do that without making sure we get paid, right?
Exactly.
All right, very good. That's all of the forms that we had for you today. And so before we close out, we just wanted to go back, and because it is the end of the year, we are in December, and by the way, happy holidays to everybody out there, and we hope that you have an amazing holiday season and a great New Year's, and we're excited to come back to you in late January, the last Tuesday in January, with yet another episode of Live with Legal. But what we wanted to do was go through and talk to you about some of the top legal issues. Some of them we talked about already, but we just wanted to reiterate some of them as we close out 2018. So the first one, kind of our top legal issues for
Right.
2018, was cybersecurity, right?
Yep.
And so cybersecurity is one of those things where, everybody just has to get on board. You've
do.
got to realize that this is the real deal. This is no longer just some, conversation that some people are having. There are really bad people out there that are hacking into everyone's systems, individual systems, corporate systems. They're hacking
Yes.
into Facebook. And so we have to be really aware, we have to be diligent. And so
We
what
do.
are some really important things that they should know about that, Martha?
Well, I know we've belabored this on many, many fronts, and I know you get email blasts from Mary Lee, from Dean, from me, from Sam, from Dee Dee Mattson, our director of IT here, but it is so important, and it's an incumbent upon the agent to really educate your client that it's real. I don't think we have to do it as much as we did several years ago, because it's so out in the media and everyone knows. I mean, we've all been compromised one way or another through Target or our bank or you name it. They can pierce through any protection wall, it seems, at this point. So we always try to stay one step ahead of the hackers. And in doing so, I just always tell people, if there were 3 things that you can do to help prevent cyber fraud, it is to talk to your client, have them sign the anti-fraud disclosure. Up front. Collecting that, by the way, on the eve of the close of escrow is not going to really help your client, so you need to do that right up front.
Yes.
We'll talk about that in just a second. The other one is, don't open up any strange emails, and do not click on any links. Just be very, very careful. That is how the hackers are able to install spyware, so be very, very diligent there. And my goodness, do not send wire instructions. We have agents that tell me that there are escrow companies and title companies out there that are still sending them wire instructions. So that's probably the death knell for a lot of these agents that do that, because they're wiring them. It gets intercepted between the time it goes from my email to the client's email. The hacker gets it, scrubs it, plugs in a different routing number, a different account number. It lands in the buyer's email, and then poof, there goes the money. So be very, very careful. And along those lines, make sure you use a SOC 1, SOC 2 certified title and escrow company.
All important things, and I'll only add that I personally think you should use the Berkshire Hathaway. If you're with our company and you're watching this and you're a Berkshire Hathaway agent, obviously we want you to be protected, and we want your clients to be protected. So using our email infrastructure, the at bhhscal.com email. Now I get it. I get why you may want to use your own domain, and trust me, I get it. The question I'd like you to ask yourself and ask, frankly, your clients is what's in their best interest. And so I think if you ask that question, you'll know which way to go, okay?
Right.
So,
and if you're not, if I may make one more suggestion, if you're not using a BHHS email, make sure you're using something that has an MFA, which is called multi-factor authentication, which means if somebody else is trying to access your emails from an unauthorized device, you're going to get a text message.
Yep.
So make sure you do that.
Yep, important stuff.
Yep.
Copyright infringement is the next item. Yes, Dean, tell us a little bit about what's happening there.
You know, on the copyright piece, you know, we're seeing more and more cases that are coming up where agents have pulled a photo out of off the internet. They may not even see that it is copyright protected, so they think it's okay to use it. So they'll put it on their website, they'll put it in a flyer, and before you know it, we're in trouble for copyright infringement. So it doesn't even have to state that it's copyright protected in order to be so.
Yeah.
So we just have to be super careful. And as you know, anything that goes on the internet lives forever.
Yes.
So it gets syndicated out to the rest of the world. So we have to be extra careful.
Yes.
And I will say that all of the images that we use today, we've either purchased or they came from our bank of images that we had. So none of them, we're not violating any copyright here, all right? Next one is the TCPA. So this is a big one. And this is going to be unfortunate for some of our agents, right? This is a tough one. For those of you that may be using auto dialers, or some of you that are hiring robo-type calling systems, right? So, Martha?
Right. TCPA stands for Telephone Consumer Protection Act, and it is a really big boom right now. There are a lot of plaintiffs' lawyers out there that are licking their chops because there are some new laws with TCPA about what you can and can't do with consumers. So as we all know, we have the do not call list, the registry. Very easy to log on to that, by the way. And we really discussed copyright and TCPA on our last Talking with Legal, discussions with legal. So you can actually go and get more of a broad brush information on that if you want to go back and re-listen to that. But I'll suffice it to say, if you are using a robo system or any of these auto dialers, stop. Just simply stop. Don't do it unless you have express written permission from those individuals on that list, which I seriously doubt you do, because that's the whole design, is to call thousands of people at a time. You are not permitted to use that without infringing on TCPA. So it's very different from the do not call list. Those are two separate portions of the TCPA, but make sure you're either, if you're cold calling, you need to make sure somebody's not on the do not call list, and if they are, don't call them. And then no robo or automatic dial.
I think this is a big enough issue where we will host a webinar for those of you, because I know we have a lot of you that are doing what you're supposed to do, is prospect, right? You're supposed to go out and find people who need to buy or sell, and I get it. I, in fact, used to use an auto dialer, and in some cases they would dial 3 lines at a time, right? And I would pick up the one that would pick up, right? And so there's a lot of consequences with using that with the new act that was recently enforced. So look for a webinar coming out soon on this topic, so we can give you a lot of good information and make sure that you don't find yourself into a bind, right? Okay. Next one is team names. Team names. Dean, you want to share with us what we're looking for there?
You know, we talked a lot about this earlier in the year, and now I think we've pretty much gotten into compliance, but just as a point of quick clarification, if you use your surname and you're going to include the terms group, associates, or group associates or team, then you're good. But if you're going to use a name that's unassociated with your surname, and it's going to be like Delmar Heights Real Estate Group, then you've got to file a DBA for that. And we will do that for you, but you cannot use first names as a DBA. We found that out the hard way.
Yeah.
Yeah, very important that you need to know. And make sure that your signage all matches up for everything, right? Because I still see a lot of practitioners, many of them are not with Berkshire Hathaway, but I see a lot of practitioners out there where they just have, Tom and Mary, and they will soon find out that, that you can't do that anymore, okay? The next one I'll take is the DRE number. You got to have that on everything, right? You got to make sure that anything that is considered a first point of contact for any of these services, that you have your DRE number on there. Now, it's still a little ambiguous as to social media, but you want to make sure that on your profile account that you have on that main landing page, on your profile information, make sure that your DRE number is on there. And I got to tell you, it can't hurt. You might as well make it a hashtag. Hashtag DRE number. You're the only one that has it. So if anybody else hashtags it, terrific, right? So for what it's worth, right?
We also want to state on here that, that we have the broker's name as prominent as the agent name or the team name. So Dean's well aware of this because Dean gets cited on all the letters that we've got, the corrective action letters. So that is not a Berkshire Hathaway requirement, a branding guideline, or anything like that. That is a DRE regulation that you cannot have Martha Mosier with Berkshire Hathaway down in a little pin size in the very far left corner. It needs to be as prominent.
Yeah, and that's a DRE requirement. That's not our idea.
Right, and we've gotten a few corrective action letters, have we not, on
Absolutely.
that? Yeah.
And same goes for if you're going to put your license number on your signs or your posts or whatever it is, don't make it microscopic. Make it so that you can read it. I always look through. I get so many emails of people promoting their property, so I always just take a quick look at it, and it's amazing to me how small that DRE license number is. Let's be proud of it. Put it up there.
Yeah. Very good, very good. And the last one, of course, we talked a lot about it already, is the square footage. We really have to start making sure that we disclose all of those sources on the square footage. It is the latest hot button. It's the latest thing that plaintiff attorneys are looking at as a quick way to frankly settle a case. Many of these cases are not going to make their way all the way into a courtroom, but they will settle, and settling costs money. And it's a lot of headache and puts you through a lot of unnecessary stress, to your seller as well. So make sure that you take that very, very seriously, okay?
Yeah, it's just surprising how much money it takes to get these things done.
Well, yeah, if you start thinking about it on a price per square foot basis,
like that.
Yes.
Which we all know never factors into price because it never works.
Of course
right?
not. Yeah. It worked for them when they thought it was, exactly 3,500 or 4,000 square feet. Why isn't it working for them when it's on paper a little less? So.
Right. So, just make sure that you do all that you can to disclose everything that you can with regards to those square footage. So. Thank you, everybody. So we made it.
Thank you. Happy holidays, everyone.
You.
So this was the last of our Live with Legal for 2018. I hope that you enjoyed it. Thank you to Sydney for working so hard to help me put all of this together. She's behind the camera. You can't see her, but she did a good job as well. And we'll see you next month with Live with Legal. Thank you guys for being here.
Yeah, absolutely.
Thanks everyone.
Bye-bye.